Well, one Oklahoma case the Supreme Court will hear this week involves a death row inmate who has been up for execution 9 times.
On Wednesday, justices will review the case of Richard Glossip. He was sentenced to die for the 1997 murder of motel owner Barry Van Treese. Glossip maintains his innocence.
His bid for freedom even has the backing of several Republican lawmakers and the state's attorney general. News 4's Spencer Humphrey is here with what they're asking the U.S. Supreme Court to do. Spencer?
Yeah, guys, they want the U.S. Supreme Court to allow Glossip to have a new trial after they say prosecutors in his first ones knowingly withheld evidence and information that could have resulted in a different verdict. Oklahoma's Attorney General joining forces with attorneys for death row inmate Richard Glossip this week, making a plea to the U.S. Supreme Court to spare Glossip's life. Glossip has always said he was innocent in a case that dates back nearly 30 years to 1997 when Justin Sneed admitted to killing Barry Van Treese, the owner of an Oklahoma City motel where Glossip and Sneed worked. At trial, Sneed testified Glossip paid him $10,000 to kill Van Treese. In exchange for his testimony against Glossip, prosecutors did not ask for Sneed to be put to death. Meanwhile, Glossip was sentenced to die in 1998. He faced 9 different execution dates since 2015, postponed in large part by legal appeals from Glossip, whose attorney says prosecutors knew Sneed, their key witness, lied on the stand when he testified against Glossip and never told anyone.
2 independent investigations as well discovered information that shows that Justin Sneed was lying about his use of, or whether he was prescribed lithium, whether he was under the care of a psychiatrist at the county jail, that the prosecutor at the time knew these things to be true, and she didn't correct Sneed at all.
Oklahoma Attorney General Gentner Drummond stepping in as well after he discovered a box with key evidence inside had been destroyed and never shared with Glossip's defense team before trial. Legal experts say that's a problem.
The prosecutor has an extra burden to make sure their witnesses are telling the truth and to make sure they've given all the evidence, including evidence that might benefit the defendant, to the defense before the trial.
A.G. Drummond says prosecutors violated Glossip's rights by not sharing that evidence in a statement telling us Oklahomans deserve to have absolute faith that the death penalty is administered fairly and with certainty. I don't believe that justice is served by executing a man based on the testimony of a compromised witness. Now, it all lies in the hands of the U.S. Supreme Court, who on Wednesday will hear arguments from Drummond and Glossip's lawyers. They want the court to grant Glossip a new trial.
That an attorney general of a deeply conservative state can see that a person did not get a fair trial and has the courage to stand up and say, this person did not get a fair trial, and we are not going to execute someone who didn't receive a fair trial. It is imperative in our system for all of us that we have the opportunity to have a fair trial.
And we're also hearing from the family of Barry Van Treese. In a filing to the U.S. Supreme Court, the family's attorneys asked for Glossip's conviction to be upheld, writing, the Van Treese family has waited patiently for justice for 10,047 days, and yet they are now witnessing the spectacle of their case being stalled by the Attorney General for their home state confessing an error where none exists.